Yes.
Back into tab 47 and withdrawal agreement.
No, I
Thank you, my lord.
was smiling because we seem to have got another additional authority. Is that right?
Nothing to do with me.
No?
Well, I've provided that.
Okay, don't worry, we'll come to it later. Thank you.
If there were.
Yes.
So, we were in the withdrawal agreement.
Yes.
And Article 13, this was just to make a point, which is that we agree that these residence rights are not applicable to extended family members. And so, therefore, Article 13(4) is also not relevant for the appellant. So that then takes me to Article 18.
Yes.
Could I start by dealing with what this new resident status actually is? Because this is the battleground in the IMA case, which the Secretary of State lost. So the submissions I made with Mr. Blundell were rejected. So what the Secretary of State argued in that case was that Article 18 was envisaging a truly constitutive scheme, so really something like Article 3(2). In other words, that the residence document would be constitutive of the right to reside. What the Commission and the IMA argued in that case was that no, it doesn't do that, it's really just a beneficiary status. So it's a bit of paper that proves that you can benefit from the withdrawal agreement, but in order to know whether somebody's actually got a right to reside, you need to look and see whether they're complying with the conditions in Article 13. So the Secretary of State's conceptual analysis was rejected and the Commission and the IMA's analysis was accepted. So what it is, effectively, is a beneficiary status. So in that sense, it's very different from the Article 3(2) right, because that is truly constitutive. So the two can't be compared. Mr. Delamere said, oh, well, they're both constitutive, but that's to beg the question of what that actually means. They're actually different.
Is that judgment under appeal?
No. It's not. Westlaw says that it is, but it isn't. So permission was granted, but the application wasn't
You gave
pursued. No comment.
Not necessary.
So, but what happened was that the UK, and this is the question that my Lord Justice Lewis was asking yesterday, was that UK brought extended family members fully within its constitutive scheme, because the USC is a truly constitutive scheme, and so that's why that answers the questions about why under the domestic rules the extended family members are therefore brought under the umbrella of the EU settlement scheme.
The impression I've got is that you take the rights that you had if you were a national or a family member under Article 13 and the other rights, and they're automatically transferred into equivalent rights under the resident status. It's hard to see how that can happen, as I was saying to Mr. Delamere, because there's nothing in Title 2 to deal with extended family members. It must cover them because of persons in 18.1 and 18LM, and the impression I'm left with that it's implicit within Article 18 that that which you had as a residence right under national laws and EFM prior to withdrawal is that which you get afterwards as a minimum. If you want more, then it's probably up to the states. And that's what you're doing, is you're just providing a machinery to ease the pre-transition period national residence rights into a new status with a new document which has to be at least the same as what was there before.
Yes, so effectively you'll have states doing two different things. So in states that are operating a declaratory system, they won't have this beneficiary status. So that doesn't affect any extended family.
Their pre-existing residence card will continue afterwards.
Yes.
Yeah, we trade our residence cards in, and I was unclear if you then got a new residence status just for the remaining bit, or you get something that's even longer. Mr. Delamere says it's even longer.
Well, so there are two discrete questions, because there's the rights that extended family members get under the withdrawal agreement as a matter of conceptual analysis, and then there's separately the rights that they get under the UK domestic law scheme, because that scheme is in a number of respects more generous than the withdrawal agreement requires it to be. So as a matter of under the domestic scheme, if you comply with the conditions, then you're treated like anyone else that complies with the conditions. And it's the same as other categories who were brought within scope of the EU settlement scheme but didn't actually benefit under the withdrawal agreement. So just like anyone else, you can apply for limited leave if you don't qualify for unlimited leave, and then you're effectively in the domestic law scheme. So once the relevant 5 years is up, you can then apply for what's called settled status. So it gives particularly cohorts that aren't brought within the withdrawal agreement, extended family members, and people who weren't residing in accordance with EU law at the end of the transition period get a valuable benefit from the EU settlement scheme. Once they get the settled status, they will then, it's ILR effectively, so you then get rights to benefits and so on. But in that sense, what the withdrawal agreement is doing, so far as extended family members is concerned, is saying, right, you can carry on benefiting from those rights provided you had them before the end of the transition period. And so what Article 18 allows states operating, I shouldn't use the word constitutive scheme, a beneficiary status scheme to do, is to make those people apply to get the document that confirms that they benefit from the withdrawal agreement, basically. Getting a nod.
Yeah.
So it's important, we say conceptually, to look at what IMA decides about what this resident status is, because that's another reason that it's different from an Article 3.2 application. One makes you, gives you the right, and the other, and only in states which are operating the relevant Article 18.1 scheme, shows that you benefit from the withdrawal agreement. And the states which wanted to operate Article 18.1 schemes wanted a way to make extended family members come under the umbrella, as it were. So, in any event, we say it's a very different type of scheme, Article 18.1, than the Article 3.2 process. So, for that reason alone, this provision and what this provision says can't tell you anything about the Article 3.2 right. The Article 3.2 right, you need to look to EU law, and that's what Article 4.3 tells you. So going then through Article 18 provisions, Article 18 B, C and D deal with deadlines for applications. And can I make 2 points about that? The first is a point that my Lord Justice Singh raised in argument, which is when the negotiating parties wanted to include provision for extended deadlines, they did so expressly. And the second point is to just repeat the point I made earlier, which is that this is not about extending deadlines you need to meet in order to be within scope. It's a separate question about, in a state which operates an Article 18.1 scheme, can you get extra time for applying to get your piece of paper that proves you're a beneficiary? But that's different. And if it were otherwise, if Article 18.1 allowed you to extend the scope provisions, then you'd end up with a different result in states with and without an Article 18.1 scheme. But the point is, conceptually, it's a different point. And then Article 18.1 E and F, can I just invite the court to read those? So the application process for this Article 18.1 beneficiary status, the administrative procedures have to be smooth, transparent and simple, avoid unnecessary administrative burdens, with a short application form which is user-friendly and adapted to the context of this agreement. So what the Secretary of State can't do is build into this application form a load of questions which are relevant to an Article 3.2 application. So in good faith, to meet the requirements of Article 18.1 E and F, she has deliberately maintained 2 discrete application processes. And then the withdrawal agreement itself, it's not something the Secretary of State's made up. The withdrawal agreement itself envisages two different things. The Article 3.2 application on the one hand and this application on the other, and that comes from Article 18.1L, I think. It's at the bottom of 1 to 70. So, for it, the host state may only require family members who fall under, blah blah, Article 10.2 or 3 of the agreement and who reside in the host state in accordance with point D of Article 7.1 or 7.2 to present, in addition to the identity documents, and then D, for the persons referred to in Article 10.2 or 3, a document issued by the relevant authority in the host state in accordance with 3.2. So it's a separate document, and the withdrawal agreement recognises that it's a separate document. Contrast that then to the provision before, which is K. Which is M. I'm sorry, it's the provision afterwards. So M is dealing with people who are outside the host state at the end of the transition period, and that doesn't allow you to have a document issued under the 2016 regulation. So this is another example of the withdrawal agreement treating differently people who were in the host state, who needed to be complying with EU law, and so for an EFM that means you need a document, and for people outside the host state, which is M, where they won't need a document. Because they were outside the host state, they didn't need to be complying with its requirements. Article 18.10, the competent authority shall help the applicants to prove their eligibility and to avoid errors or omissions, and give the applicants the opportunity to furnish supplementary evidence and to correct any deficiencies. Now, what Mr Delamere submitted was that the same logic and controls applied to Article 3.2, but that's wrong. First, as I've submitted, it's a different process. This process under Article 18.1 is a new process which is only operated in states which have introduced it. So what it's doing is it's fundamentally introducing something alien to EU law, which is to say, right, you're going to have to apply to prove that you can benefit from rights. And so because it's fundamentally about introducing a new rule for people who've normally enjoyed a direct right to reside, the UK and the EU have agreed very special rules about how it should work.
Can we just go, forgive me for interrupting you, but on that point, do we need to go back to paragraph 1 and see how Article 18 is introduced? That on the face of it, it's not actually about conferring rights. What it's doing, first of all, as I read it, is the host state may require union citizens,
yes,
etc., etc. And it might be said there are two important words there. One is require, and the second is may. So it doesn't have to have this scheme. I think that introduces the submission you've just been making, that some states have introduced it, including the UK. Is that right?
Yes, about half states have introduced it, and about half states have stuck with the old declarative scheme. So this is exactly as your Lordship says. What this is doing is saying, well, if you're going to do that, this is how you're going to have to go about it. So what it doesn't do is tell you anything about what you need to do to get the Article 3.2 right, because that's governed by EU law. And
is it also your submission that you show this paragraph L, sub-Roman paragraph 4, and I just want to be sure I understood your submission about that. I think what you're saying is that expressly links the persons referred to in Article 10.2 or 3 of this agreement to the process in Article 3.2 of the directive.
exactly. So what it's doing is saying all states which are operating an Article 18.1 scheme, they can insist on requiring somebody relying on Article 10.2 or 3 to provide the document that Article 10.2 or 3 requires them to have applied for. So it expressly recognises that there are two different things going on. There's the discrete requirement to get yourself within scope, to have applied at least for the document and ultimately to be successful. And then there's this separate process for making people apply for what's a beneficiary status, but you don't have to do any of this if you don't make them apply. So in states which aren't operating a scheme like this, Article 18.10 just wouldn't apply. So nobody could go along, I don't know, let's say, I don't know if France does or doesn't, but say France doesn't have an Article 18.1 scheme, nobody could go to France and say, well, hold on a minute, my Article 3.2 form wasn't user-friendly, because France would say, well, we're not even applying Article 18.
That's why it doesn't help, because if they don't use the USS scheme, there's never going to be a situation where they apply for anything other than a residence card under Article 3.2. The problem only arises when you have the first issue, get a residence card, and the second issue, a new residence status evidenced by a new document which takes the old one and transfers it into a new one. And I understand all that you say about there being two discrete schemes, but I wonder whether that answers the question of, if you've applied for the wrong one, and if you're going to take a decision after the time by which you could apply for the right one, and if it has drastic consequences, is there an obligation in domestic law, or possibly EU law, to send it back and say, got the wrong end of the stick, mate, I know it's complicated, but what you should be applying for is the residence card, not the thing. So just because there are two doesn't entirely answer the Delamere Ward thesis that you must go back and ask for the right one, or send them the right one.
No,
but you say it's powerful evidence that you have two schemes, and the fact that the first scheme is based on national law means you can decide how to run it, basically.
You can decide how to run it, but even with EU law and domestic law controls, to say that the state's got to pick through, it's a point I made before lunch, someone need only say, I'm a durable partner, and that triggers an obligation on the state to advise them as to what the withdrawal agreement says, to give them the form, to get them to fill out the form, and to do it all in time for them to apply. But people have to be taken to know what the law is, and it's not for the Secretary of State, we say, to do that for them. The fact is that the withdrawal agreement envisages that, but in any state, the Secretary of State, I'm sorry, I was distracted by Mr. Delamere. The Secretary of State is, the withdrawal agreement, Article 10.2 or 3 says this is how you get within, you have to make this application. So forgetting about Article 18, that has to be done. Now, the fact that the withdrawal agreement then allows states to introduce a beneficiary status type scheme doesn't mean that somebody cannot do that. That there's nothing, but the fact that the state can introduce a second set of rules doesn't put an obligation on those states to assist somebody with their Article 3.2 application. If not, I mean, why not have that in a state which isn't operating a constitutive scheme, because the cliff edge is the same. In France, which may or may not have a constitutive scheme, we're assuming it doesn't, then let's say, well, in France, the person's subject to the same problem. Maybe they made a different application, but France would say, but that's not, this is our Article 3.2 process, and you haven't complied with it, either in form or in substance. So, yes, but that's what the withdrawal agreement does, and there is no obligation on the Secretary of State, we say, to alleviate some of the effect of exit or the rules in the withdrawal agreement. Now, it's right to say, and it's been recognised in some of the early case law, that she has done that to a significant extent, because she's put processes in place to help people apply under the EU settlement scheme and so on. But in my submission, as a fundamental point of principle, it's not her obligation to help people meet their legal obligations and proactively to filter through their applications and work out what they're doing. As I say, that the logic of the Delamere Ward thesis is that then that must apply to any application of any kind which happens to use the words durable partner, and that simply can't be right in my submission.
Mr. Myers, I'm just trying to understand your submission, and I may not, forgive me if I haven't. is another way of summarising your submission to say that whatever Article 3.2 of the directive did or did not require, it hasn't altered as a result of the withdrawal agreement.
Precisely so. And your Lordship, as always, puts it so much better.
No. I just want to be sure if I've understood it.
It's exactly that. The Article 3.2 right remains the same, and that one can see that very clearly by looking at what would be the position in a declaratory state.
But what the other side say against you is that's all very well when you had time to apply again, but the world has changed. This is their last chance. And they say, although my Lord is right to say that the requirements of Article 3.2 haven't changed, other things bear down on the Secretary of State to say, look, if you're going to take 6 months even to read the form, it came in August, you don't get to reply until March, when it's far too late for them to do anything about it. If you'd written back in August, they could have found some registry office in Newcastle or Gwynedd, but they could have got married, you know.
Well, with respect in this
But you say it's not their obligation?
Yes, I mean this appellant shouldn't have been in a relationship at all. He was here unlawfully. He was required at all times to regularise his position. So that's the first point. The second point is that he was always required to apply under the Article 3.2 procedure. If he thought the Secretary of State was taking too long, he could have brought a judicial review and said there's unlawful delay. He did not. The third point is that the Secretary of State made clear in the statement of intent this is what was required. Her website says if you are an extended family member you need a residence card. He didn't apply for one. And her use application form asks, have you got a residence document? So what yes, it's difficult. One acknowledges that it is difficult, but the difficulty in my submission is not created by any breach of any legal principle by the Secretary of State, and in my submission no legal principle which could impose what are very onerous obligations on her can be read into any of this. What does it is the withdrawal agreement, and it is inevitably the case, and it has to be accepted, that it causes problems for individuals that the UK has left the EU. That there may be other people who, for all sorts of reasons, had the UK stayed in the EU for another year, could have applied for rights, could have benefited from rights, all sorts of personal reasons, and many of them are likely to be more personally compelling perhaps than happening to stay in a state unlawfully and getting into a relationship. But the point is in our submission that those consequences flow from the withdrawal agreement itself, from the fact that it requires that that application be made. So, coming back then, I've finished in Article 18. Article 20 was referred to. This is about restrictions on the right of residence. I just wanted to show the court Article 20 sub 1 as an example of a case where, for example, there would be a full analysis under the Charter. So what Article 21 says is the conduct of Union citizens or UK nationals, their family members and other persons who exercise rights under this title, where the conduct occurred before the end of the transition period, shall be considered in accordance with Chapter 6. So if you commit your crime on the 30th of December, the old EU law public policy test applies. But if you commit your crime on the 3rd of January, the position is different. So that's Article 22. That's governed by national law. So that's the usual, the test that this court will be familiar with, conducive, and also the automatic deportation rules. So this is another example of where the withdrawal agreement might be said to create unfairness, because if you commit your crime 3 days earlier, you're in a better position than if you commit it 3 days later. But again, that's the consequence of the UK having left. So the withdrawal agreement itself sets up a difference in the position before and after the end of the withdrawal agreement. Similarly, perhaps somebody who was prevented from travelling to the UK wanted to because of serious illness might say, oh, well, that's unfair because I'd planned and I even had my ticket booked, but I got a serious diagnosis, I couldn't come. Again, unfortunately, the UK has left and the transition period ended. So the withdrawal agreement itself builds in these consequences. Finally, can I just deal with Article 21? Because certainly as I understood the submission, this was Mr. Delamere's route into arguing that the full-scale proportionality analysis applies when determining the rights of extended family members. So the analysis as I understood it is as follows. Article 21 applies the safeguards set out in Article 15 and Chapter 6 of the directive in respect of any decision by the host state that restricts residence rights of the persons referred to in Article 10. And he says if you look at Article 15, and I'll show the court provisions again in a moment, if you look at Article 15, that applies Articles 30 and 31, and Article 31 takes you back to Article 28 of the directive. Now, for a start, Article 21 is about restricting residence rights. It's not about getting them in the first place. A person who's an extended family member needs to get their card before any residence rights can be restricted, because until they've got the card, they don't have any residence rights. So even supposing that Article 21 applies to them, that's the first hurdle. But the second hurdle, we say, is the clear authority of Centulia, which essentially says, in a nutshell, the fact that you are protected by the procedural safeguards in Article 15 does not mean that you enjoy the substantive protections in Articles 27 and 28. So that was the authority I handed up. Can I take the court to it then in a little more detail?
Yes.
Your Lordships all have Centulia. So, paragraph 1 on page 587, the court says in terms, this request for a preliminary ruling concerns the interpretation of Articles 14, 15, 27 and 28. So it's directly on point in relation to what Article 15 does. And then what it does is set out the provisions in the directive. So paragraph 13 on page 589 of the report, it sets out what Article 15 says, and Mr. Delamere relied on this. Procedures provided for by Articles 30 and 31 should apply by analogy to all decisions restricting free movement of Union citizens and their family members on grounds other than public policy, public security or public health. And then it refers to Articles 27 and 28 and 30 and 31. So it's directly considering how all of these provisions interact. So paragraph 15 and 16, it sets out Articles 27 and 28, and 17 and 18, it sets out Articles 30 and 31. Now again, as I understood his submission, Mr. Delamere was relying on Article 31.3, not the first bit, which says the redress procedures shall allow for an examination of the legality of the decision as well as the facts and circumstances on which the proposed measure is based. Well, we know from Banger that there are procedural safeguards, but he relies on the second bit. They shall ensure that the decision is not disproportionate, particularly in view of the requirements of Article 28. And Miss Centulia was doing the same. So as I agree with Mr. Delamere, it was an unusual case. Miss Centulia was a spouse and she had a right to reside, but then her spouse left. So what happened was that Ireland said, well, you haven't got a right anymore. We can remove you entirely by reference to our national procedures. You can't rely on EU law safeguards, and you can't rely on EU law substantive rights. That was what Ireland said. And the court will see the arguments. Paragraph 49 is the questions, and paragraph 50 to 53 capture the arguments. So I'll just give the court a moment to read those.
2 is interesting. A claim of seeking a right is rejected by a decision which has become final and which it does not contest. Anyway, leave that to one side.
Yeah.
How far do you want us to read?
Yes, so so up to paragraph 3 is the arguments. Yes, the court does say that, and I'll show another judgment on that too. So what the court says before I take your lordships to the passages is, well, no, what she gets is the procedural protection. So she gets Articles 30 and 31, but it expressly rejects her argument that gives her the protections of Articles 27 and 28. So it's precisely the same argument as Mr. Delamere was running. It doesn't matter that the facts are different. If anything, this person's in a better position because she's already had a residence right. So she's brought herself within scope of the directive, whereas our appellant in this case hasn't. But so if it's different facts, it's a fortiori in my favour. So paragraphs 68 to 71, the court's decided that the fact that she's no longer a beneficiary, does that mean that her position is governed entirely by national law? Paragraph 68, 69, no. That question must be argued in the negative. So Ireland's full national law argument is rejected. And then what the court says at 70 and 71 is the directive doesn't only deal with substantive rules, it also lays down a set of rules intended to govern the situation in which entitlement to rights that you've got is lost. So, it says, at paragraph 71, Article 15 applies. So it then goes on to give reasons why Article 15 applies, and then it looks at what that gets her. And we've sidelined the passage at paragraph 80 onwards. So what does it mean if you're protected by Article 15? So again, I'll shut up, and could I ask the court to read paragraphs 81 to 87? Was your lordship about to say?
No, I was just noting that I understand your submission about Article 28, but what do you say about what they say in 85 about Article 31?
Well, so Article 31.3 is applicable in connection with Article 15. As I said earlier, there were two bits of Article 31.3. There's the bit that says you've got a right of appeal, and there's the bit that says that means that Article 28 applies. Now, 2 points to make. The first is that what is said in paragraph 85 needs to be read in light of Banger and what it says about the content of the procedural right. But the second crucial point is, despite the fact that Article 31.3 applies, the court says in terms that doesn't get you the protection of Articles 27 and 28. So paragraph 85 has to be read with Article 87.
I understand that, but what about the last clause of paragraph 85? Also ensure the decision is not disproportionate. Because
this is the point about one has to look at the right that's being examined. So this is an extended family member right. See Rahman, there isn't a requirement to apply proportionality to decide whether or not the person gets the right. Mr. Delamere's argument was that you get that from Article 28, and that's flatly contrary to this case.
So, are you saying that if you are taking, I'm not quite sure what you're saying, because she didn't have the right, but she was being removed, you have to look at proportionality there. Say she lived there for 25 years, had 3 children, 6 grandchildren, and a great-grandchild. You'd have to look at the proportionality according to paragraph 85 there, wouldn't you?
Well, it raises interesting questions that this country won't have to answer,
We've
because
left.
it's right to say that it's certainly, I mean, one has some sympathy with Ireland's position, which is why does she get any EU law protections at all? Because she's
She
not
hasn't got the
deciding in
right.
accordance with EU law, but the court comes up with a halfway house, which is, well, you can have the procedural safeguards, but what you can't have is the detail. Articles 27 and 28 are very detailed provisions spelling out lots of things that have to be considered, including proportionality. But the difference, and we say our situation is a fortiori, is that in our case, the person hasn't got the right yet.
But I think proportionality is still in. You don't get 27, which is proportionality dealing with the personal conduct and threat to society and so on. It's not ruling out proportionality in all circumstances. So 27 is dealing with that. 28 deals with something else. But proportionality generally is still there. And I'm sure sometimes I would say you've got to ask whether it's proportionate, either not to consider the form as a request, please let me stay here because I have a partner, or alternatively, if you do look at it like that, whether or not you should let him stay here, because whilst normally you'd have 2 years, in a time when you're dealing with, you only got 8 months anyway before the end of the agreement, maybe it's proportionate to take a shorter time.
Well, that then in my submission is that's the first question about is there a durable partnership. That the answer to that question doesn't change by reference to the principle of proportionality. Either there is a durable partnership or there isn't, and that's for the member state to decide. That's the first point. The second point is that paragraph 80, this is describing the content of the procedural right in a Centulia case, which is someone who has enjoyed an EU law right, and which the court has said, it uses the word, you are losing that right. Our situation is the extended family member right, which is a discrete right, which you get by reference to national criteria. So paragraph 85, in terms of what's the content of the procedural right, the procedural safeguards in an EFM case, see paragraphs 50 to 52 of Banger. And nowhere there is it said, well, you've got to decide whether it's proportionate or not to give the person a residence card. It says you go to the court on very specific. The court's got a very limited role. So there were just 2 more provisions to mention in the withdrawal agreement, just so that the court has them. And I apologise, one of them didn't make its way into the bundle, but it's Article 132. We did hand it up. It allows the transition period to be extended.
Did we get it yesterday?
I think it was this morning. Yes, it was this morning, and we have more here. This one. Yeah.
I've got my own, don't worry.
It's
132.
Yes. I don't really need to say anything about it. I just wanted the court to have it because we reference it in our skeleton.
I don't think if we haven't got it. Well, I haven't got it. We haven't got it.
So all I need to say about that is that's a provision for extending the withdrawal agreement, and the joint committee could have done that before the 1st of July 2020, adopt a single decision extending the transition period. And the other point to mention is Article 1645D, which is in the bundle.
Yes. Sorry, Article
1645D, which is at page 1286. So it's by the bottom hole punch on page 1286D. That's a special procedure to amend the agreement, and that includes to address situations unforeseen when this agreement was signed. So that was the proper way. If the agreement was going to be revisited because of COVID, that was the way of doing it. Or the transition period could have been extended.
What does it mean, except in relation to parts 1, 4 and 6?
We're in part 2.
Oh, okay, thank goodness for
we're
that.
okay.
So we're all right. I'm obsessed, as Mr. Delamere knows, with the actual words of things.
The
all right then.
structure, yes,
Yeah.
I agree. I like to have a sense of the structure. Part 2 is citizens' rights.
Yeah.
So that's my 4th topic, and my 5th one is very quick.
Yeah.
And that's to say that I've already explained why the UK operated 2 different systems, and I've also already shown the court the statement of intent. And I've already made the point that, and the language of the withdrawal agreement itself, is also a big red hand warning. But could I just briefly show the court the guidance which is in the supplementary bundle, the agreed supplementary bundle? It's not. It's screenshots basically. But I'll just show the court a couple of pages. So it is page 217. So, page 217, that's called the landing page. There are various links on that page. So, under browse EU, EEA and Commonwealth citizens, so if someone's looking for information about this, this is where they come, and they'll find various links that they can click on. The first is apply to the EU settlement scheme, settled and pre-settled. And then jump down to, there's a separate link for residence documents for foreign nationals in the UK. And then down just below the bottom hole punch, it says citizens from outside the EU, EEA and Commonwealth. There's a link to apply for a UK residence card. So that's going through that link is how you apply for the residence card under article that you need for Article 3.2. So that's the landing page. Now, anyone who clicked on the apply to the EU settlement scheme, settled and pre-settled status, which was the first link, on page 220, at the top it says the page apply to the EU settlement scheme provided other links. And then further down the page it says what you'll need to apply. You'll need to apply proof of your relationship to your family member. And then that's a clickable link, proof of your relationship. And then if the court turns over the page to page 221, it says in terms, if you're their unmarried durable partner, you must hold a relevant document issued to you under the EEA regulations on the basis that you're a durable partner of an EEA or Swiss citizen or person of Northern Ireland.
And the 4th paragraph, if you do not have relevant document, you must provide evidence of your relationship.
Yes, but that's all about. Okay, I'll come back to that. That's all about durable partners of persons of Northern Ireland, and because they're subject to special arrangements, there were circumstances in which they could not apply for a residence card.
But how do I know that? It says you must hold paragraph 1, says that it is paragraph 2. If you're the unmarried durable partner of a person of Northern Ireland, you're unlikely to have a relevant document. And then at 4, if you do not have a relevant document,
well then,
why is it limited only to the Irish, Northern Irish?
Because then if I ask the court to look at 223, which again is the information about extended family members, again it makes clear on 223 you must apply for a residence card if you're an extended family member. It's also in the legislation. There was also, if anyone wanted to read more about extended family members, there was a link to the guidance to caseworkers, and that's shown at page 226. So I'm asked by Mr. Hawkin to take the court to page 218.
Hold on, 226.
then Mr Hawkin asked me to take the court to 218. So this is a link to a different bit. This is residence documents for foreign nationals. Yes. So that says if you're the family member of an EU, EEA or Swiss citizen, you'll usually need to apply to the EU settlement scheme to continue living in the UK after 30th of June 2021. You'll either get settled or pre-settled status. It then says if you're a close family member, you have the right to reside without a document until 30th of June 2021. What's a close family member? See over the page. It's not a durable partner. Underneath that, it says if you're an extended family member, for example, a brother or sister of an EU, EEA or Swiss citizen, you need a residence document now. If you do not apply to get settled or pre-settled status, there are other documents you may be able to get. However, none of these would be valid after 31st of December 2020. That's because, of course, the UK has left and the new scheme is the EU settlement scheme. But the point is, anyone that lands on this page is being told you need a residence document now. And Mr Celik did indeed need a residence document now. So there've been certainly no complaint was made in the upper tribunal about the guidance, despite the Secretary of State putting bits of it, not as much as this, before the upper tribunal. The suggestion was made in this court that the appellant read the guidance and was confused by it, but that's now, in the light of the statement that's been more recently produced, is clear. He didn't actually read it. It was a submission. There's no evidence, and indeed the evidence is to the contrary, that this appellant read the guidance and was confused. Now, we say the guidance isn't confusing because it says you need to apply for a residence card, but the point is that this isn't, it's a simple legal question. This is not a judicial review of the guidance. If it were a judicial review of the guidance, we might be arguing about the case of A, for example. But it's not. But in any event, we say there are various links to click through, various bits of information. The message is there. The message was out there in the statement of intent that you need a residence document if you're applying as an extended family member. So just some brief points about the facts, and I will now look at the applications that were actually made. In terms of the question about why he didn't get married, we've dealt with that in paragraphs 8 and 9 of our skeleton, and I won't repeat that now. The point that we made in the upper tribunal was that if it was somehow legally relevant to decide whether or not COVID stopped him getting married, then the case should be remitted for that issue to be properly tested. Of course, we say it's simply not relevant. And that's why it wasn't tested in the first tier tribunal. So the only other thing then to do now is to look at the applications which actually were made. So again, the folder of applications, tab 2 is the August 2020 application.
I put a line through the first 3 lines because that wasn't there,
no.
And I put a line through those on each and every page.
That's right. Yes, that's right. It's this. This is the reconstruction by screenshot. So what the court will see is that the questions are not the questions that need to be asked if somebody's applying for an extended family member application. On page 7 of 15, there's some limited questions about whether there's been conviction of a criminal offence. That's to deal with, much more limited, because that's to deal with the suitability rules in the EU settlement scheme. It's right that on page 8, what is your relationship to the family member? He says, unmarried partner.
Which is the bit in the form that says this is an application for pre-settled status under the EUSS? It
will be because you click through that link on the landing page saying that you're making an application under the EU settlement scheme. So that on the website, you will be that's what you will be doing, and I'd have to get.
It's not the form itself. It's just that the person in the Home Office knows this person has had access to an Apple Mac or access to a laptop and got the form. This person could not be filling out this form online unless he or she had first clicked something saying, I want to apply under the EUSS.
Yes. I'm being helpfully told by Miss Ward that in the tribunal... apparently in one of the upper tribunal cases there's a very detailed description of landing page and how it all works, so we will find that.
Okay.
So still on page 8, there's a question, do you have a UK residence card with a biometric chip? No. So there are very limited questions on that form, none which enable the Secretary of State to answer the questions she needs to answer for an EFM application. Now, what's provided in terms of documents are, for the appellant, 2 documents that show that he and Miss Ahmed are living at the same address. Now, based simply on those documents, we submit that the Secretary of State couldn't have concluded that they were in a partnership, let alone in a durable partnership, still less that discretion should be exercised in their favour. So if your Lordship was about to ask me which document, there's an electricity bill in February 2020. It's actually not super helpful to look at it here because the pages aren't numbered, but the same material appeared elsewhere because the Secretary of State put it before the first tier tribunal. But there is not with this application, there's another one, it's February 2020.
That's the point. That's why I said to Mr. Delamere, because everyone's been saying these are exactly the same documents. I've read them, I don't think they are, but I wasn't reading them forensically.
So they're similar, it's fair to say. So if there's certainly in this application there's a council tax document.
Well, there's that, and that's dated the 29th of July.
Yes.
And it gives both of them.
Yes, and then there's an upside down document a few pages on, which is a water bill. And oddly, because as I understand it, this was the date that the couple started their relationship, it's upside down, it's South East Water, and it's his name and the 307A address, and it's dated the 24th of February 2020. So it may be that it's the same document, but it's upside down. So those are the 2 things. There are 2 things showing that he's at that address and she's at that address. That does not enable the Secretary of State to conclude that they are partners. Nor does it enable the Secretary of State to conclude that they are durable partners, because they could be friends living in the same property. They could be flat sharing. So simply saying unmarried partner and providing a couple of bills is not enough, and certainly it's not enough to show the Secretary of State that it's a durable partnership, and it certainly isn't enough to address all the factors that the Secretary of State needs to consider in order to exercise her discretion. That's why she's got a separate form. Sorry,
I may be looking at this the wrong way, but there's no respondent's notice in this appeal. Did these reasons feature in the upper tribunal's decision?
Which?
Well,
no, because the arguments weren't made in the tribunal. That we're making them in response to the new arguments that are being put by the interveners, and in fairness to us, at quite a late stage in these proceedings. Right. So the arguments were simply not advanced in the same way at the upper tribunal. So to answer the submission that now there was an application within Article 10, 2 and 3.
That's a fair response. Thank you for that. But digging below that to perhaps a more substantive point, we've seen the reasons for refusal including the reasons for refusal on the 23rd of June, which is the decision under appeal. But I don't recall that said, the evidence you provided doesn't enable me to conclude that you have a durable partnership. It seems to say, but correct me if I'm wrong, that you haven't got the relevant residence card.
No, exactly, it doesn't, because it was addressing the application that was made rather than an application.
Well, that I understand, and that may be sufficient for your purposes.
Yes.
All I'm wondering at the moment is whether you're entitled to show us these documents to make a distinct submission, which is that even if the Secretary of State had considered this point, she would have been compelled to reach an adverse conclusion.
I'm not making the point in that way. I'm making it as a submission to show the difference between the two forms. Because the submission I'm meeting is, well, the Secretary of State should have treated this application as an EFM application, and the answer and such an application was made in substance. That's the argument that was advanced by the interveners, and our answer to it is, well, that's wrong.
Yes.
It's wrong because they're different, and it's wrong because if you understand how they work and how the applications are made, it's wrong. It's not a discrete submission in relation to a appeal that the court can refuse it for the discrete reason that he would have been refused as a durable partner. It's going to the point that's made under ground 2.
And I get the impression, I don't know, I asked for these documents. I did wonder whether I should really, because it's new evidence. These documents, and whether or not they could be read as an application, or should have been read as an application for a residence card. None of these documents was in evidence, as I understand it, before the tribunal, or is that a mistake? They weren't before the tribunal.
That's right, because the arguments weren't made in that form. And of course, if the interveners are to come in, and we haven't taken points about the interveners, we understand it's an important point, but if the interveners are to come in and say, well, an application was made in substance and the Secretary of State should have treated it as such, then the Secretary of State, in my submission, has to be allowed to make a case on that point. Otherwise, the point shouldn't be dealt with in this court at all. It should be dealt with by the tribunal below. And if it had been, and if those points, if Mr. Delamere and Miss Ward had intervened in the upper tribunal, then we would have made those points then, and then I wouldn't be standing in this court effectively having to make them now. So we say we've been fair to the interveners, but if the point is to be decided, then it needs to be decided on all of the material. It's unusual in that the point was made by the intervener, because normally, if the point had been made by the appellant, I would say, well, you've got a duty of candour. So produce the application that you've made, that you say in substance was an application as an extended family member, and then we'll have arguments about it. But the interveners made it obvious to them simply by looking at the papers and drawing conclusions from them. But that's if those arguments are to be entertained, and they have to be entertained in light of all the material.
My Lord, I hesitate to rise to my feet, but in fairness to the appellants, the IT infrastructure of this application process means that the appellant can't provide the material that's been provided to the court in the form with the contextual information that's been provided. So.
Thank you.
Yes, I think my point is a simple one, that it isn't really Mr. Hawking who said I made an application in substance, and indeed he might not have made that submission, taking instructions from his client about what his client actually provided when he was making his application.
And then the 17th of March, when at tab 3, and going to the 5th page of that, just so that I understand it, second box says, how are you applying? And the words based on your relationship to or someone eligible for the EU settlement scheme. Is that filled in, or is that just something on the form?
Sorry, which page, my lord?
Tab 3, page 5. I'm trying to work out what the second application was.
Can I just turn my back?
Yeah.
Because I've got somebody here that understands. So. I'm I'm told that those boxes, the second, third and fourth box on page 5, will be drop-down boxes. So it's not something that the person picks the answer.
Right, so is there anyone, 2, 3? So he hasn't picked spouse or civil partner either, is he? I mean, when you say drop-down box, has he selected that? You know, when you go book a cinema ticket, they ask you for your title, and you pick one, Mr. or Ms. in your case. Is that what happened? He's picked the word spouse or civil partner.
And the final box, yes, he has.
And has he picked the words based on your relationship to someone eligible?
Yes, but I can't say at the moment. We can provide it, but I can't say what the other box is. Yes, we did provide, at tab 5, we've provided a form, a blank application form, which is, it's just to show the court the application form, and on page 1 of that form, it's only issued to people who are having difficulty applying through the online application form, so it's not routinely sent out. But
the question then is if that's what he's ticked, is relationship to a person eligible for the youth settlement scheme and spouse or partner, Miss Ward will say, well, doesn't that show that because in the decision letter of whatever date it is, June, they went on to consider not just spouse or civil partner, but went on to consider durable partner, that they must not just have been considering this application, there must have been a resurrection or a breathing of life into the first application, what Miss Ward would say, I think.
No, because under the immigration rules, if you apply as a spouse and you weren't married by the relevant date, then you qualify, provided you married later but you were in a durable partnership at an earlier date.
Okay.
So that's why the Secretary of State considers the durable partner point. While we're here and talking about the second application, the main point we say is that it's not a reconsideration. What it is a fresh application which then gets a new decision.
I understand that. It's why the second decision letter is referring to...
That's why.
Yeah, and if at some stage, not necessarily now, by email at some stage, not because I don't believe a word you say, but just for my note.
I can show you Lordship now.
Oh, you've got it, have you? Sorry.
I know.
I don't just sound distrustful.
Yes. So it's in the rules. They are at tab 58.
Ah, right.
It's on page 1533. So it's in family member of a relevant EEA citizen, and then in lim A, the spouse or civil partner of a relevant EEA citizen, and 1, the marriage was contracted. So you're married by now. 1, that the marriage was contracted or the civil partnership was formed before the specified date, or 2, the applicant was the durable partner before the specified date. So that's why the Secretary of State considers it.
We were showing this yesterday.
Yes.
I always try, if I may say so, to mark carefully which party has shown us a particular passage. We've shown this by the appellant, and I certainly understood, precisely as you submitted, that that's why the 23rd of June letter was drafted as it was.
Yes.
It was not, and I'll be corrected if I'm wrong in reply, but I did not understand that as amounting to a reconsideration of the March decision.
No, and it wasn't. For that reason, and also just because of general principle, because in the immigration context, if somebody makes a new application, they'll get a new decision. It's not like a decision-making process which isn't by application, where somebody might write and say, I want you to do this, and the government department says no, and then the person might back and say, well, will you reconsider it on that basis? That's a reconsideration. This is simply application 1, decision, application 2, decision.
It's a necessary part of application 2. You go through the hoops of spouse, civil partner, if not durable partner.
Yes, to answer it, exactly.
And the drop-down box doesn't distinguish between 1 and 2.
The drop-down box, I'll put it there now.
And we don't know, because we don't know what else is on the box. So we don't know what other drop-down options there are.
No, but I can, two things. I can ask somebody to look into it, and I can also ask somebody to show us on if a hard copy application has been made, where that is.
Yeah.
That's why that answers the question actually.
Right, I'm being told there's an unmarried partner option, and that's what was selected for the first application. The second application is the spouse option.
So you could select a married partner option, but if you select the civil partner or married partner, whichever it is, that will necessarily involve you going through two things, as you've just shown us on the rules. Before you finish your decision letter, you'd have to say you're not a spouse and you don't meet the rest of the rules that apply to spouses.
If somebody applies as a spouse, yes, because it's okay to get married later, but then you need to look back and see if
Yes.
the requirements were met.
Yes.
So 3.18 of the hard copy form on page 16, there's a section there about your EEA or Swiss citizen family member details. 3.18
Oh, yeah.
asks, what is your relationship?
I see it, yes. Yeah, okay.
So that takes me away from the facts. I'm going to summarise my position on which is the fifth part on the grounds, but just a couple of broader points of context and mop up a couple of points from yesterday. The first is that there were two categories of persons. There are those who weren't in a durable partnership at the end of the transition period, and they necessarily had to rely on getting married. Now, Mr. Celik seems to suggest he thought he was in that category. It doesn't matter because we say he loses anyway. And then separately, those who could have qualified as an extended family member but didn't apply. So, but those who could have qualified as an extended family member but didn't apply, just to note that there are different groups in that second category, and those were the issues that were mentioned in the Minister's letter that the court looked at yesterday. So for someone who didn't apply under the EEA regulations but actually had some other lawful basis of stay, so supposing somebody is here as a student and got into a relationship with an EEA national, obviously they wouldn't apply under the EEA regulations because their status was already regularised because they had leave to remain. That there's a discrete provision in the rules which allows such a person, effectively they're called a joining family member, but that person doesn't need to provide a document, and the difference between that person and the appellant is that that person was here lawfully. Now that, I won't go back to it unless your Lordship would like me to, but my Lord Justice Lewis was querying yesterday, well, why isn't the appellant relying on this provision? That's what that provision is about.
Okay.
The other thing, and again in provision which goes beyond the withdrawal agreement, is that if somebody was here unlawfully and didn't apply for a residence card, they still, and the appellant still has this option, they are permitted under the UK scheme to leave for 6 months and then reapply from out of country. And again, that's catered for in the rules.
So
And then
would that be a way of this appellant regularising
well,
his?
he's already done that because he's got leave under Appendix FM, which is another route, it's a human rights route. Now, for anyone who was here unlawfully, it's easier for them to meet the requirements of the rules. For anyone who was here unlawfully, they will need to meet EX1 in Appendix FM, but this appellant did because of his relationship with the child. So he has regularised his status, but that's an option for others as well.
So I've got confused. Before we get to him, permitted to leave for 6 months and apply, who would want to do that if they could get in under the third category anyway? Who's going to leave for 6 months?
But sorry, the third category?
No, you said some people, you're always permitted to leave the United Kingdom for 6 months and come back. Which category of people would that
So
apply
Mr.
to?
Celik, because he was here unlawfully,
Yeah,
if he couldn't have got leave under Appendix FM,
I see.
somebody doesn't need to do that if they were here lawfully because they've got the other option, because the Secretary of State doesn't need them to provide an Article 3.2 document because they were here lawfully and so they wouldn't have applied for one. So that's why the rules are drafted as they are.
Yeah. I'm stuck on this at the moment. It's my fault. It's the end of a long day. You said that for some people, they could leave for 6 months and then reapply. And I don't know which category of people those would be, because Mr. Celik, who just told us, didn't have to do that. He didn't have to go away from his wife and stepchild for 6 months. He just told us that he could get in under FM, the Appendix of the Rules, and did.
He did. But somebody perhaps who didn't have the option of applying,
who didn't have a family.
Yes,
wife,
I mean that would be difficult because they otherwise a durable partner. So, but it might be someone who doesn't meet EX. It's called EX1 because it means if you're relying on a relationship with a UK or an EU national, a settled person, as I understand it, but you were here unlawfully at a particular point in time, you then go through to what's called EX1, and that imposes particular requirements like insurmountable obstacles and so on. So somebody might not meet the requirements.
Somebody might have not got in under FM, and they'd have to go for 6 months and then come back.
They could.
But he didn't apply. Why is he appealing if he's got?
Well, we accepted that the appeal wasn't academic because his rights would be different. He would be able to come in under Appendix EU, and that would give him a different route to settlement than Appendix.
There will be a difference. He's better off if he gets in under the EU route than under this route.
He may take that view. They're two different schemes, but yes.
A much quicker route to settlement, my lord.
So he'd be safer, and
So that's why we said in our skeleton he's got leave, but we didn't take the point that it was academic. So finally, I didn't realise it was only 3:15. Don't worry, that doesn't mean I'm going to take longer.
Time flies when you're having fun.
Doesn't it just? I'm having fun. I apologise if your lordships and everyone else isn't. What I'm going to do is just wrap everything up, take the grounds in order.
Yeah.
But I've made most of my submissions as I go along. So that the headlines I made at the beginning of my submissions, we say he wasn't married, so there's no scope to disapply Article 10(1). He didn't apply as an extended family member, and none of the arguments about why he did or should be treated as having done so are right, and all the other grounds advanced by Mr. Hawkin are wrong. He didn't say a great deal about those in oral submissions, so I won't say a great deal about those because I will rely on our skeleton. So can I then start with grounds 1, 5 and 6, which were rolled up together?
Yeah.
And this submission was that this should include someone who'd intended to and taken steps to marry an EU citizen but was unable to do so. And adopting the words of my Lord Justice Lewis, we agree that this would require you to change Article 10 quite a lot, and we say would lead to all manner of practical problems. And I know this is not a point rightly supported by the interveners. It simply involves disapplying the clear terms of the withdrawal agreement. The upper tribunal was right at paragraph 65 to describe this as a remarkable proposition. The submission is set out in our skeleton on these grounds. I don't need to address it any further, save to say that in oral submissions, my learned friend placed reliance on Article 32 of the Vienna Convention, but that only applies if the meaning is ambiguous or obscure, or if the construction leads to a result which is manifestly absurd or unreasonable. So that threshold is not met.
But he submits that it's manifestly absurd and unreasonable because of the devastating impact of COVID.
He does, and we say that the withdrawal agreement itself does not lead to results which are manifestly absurd or unreasonable, requiring people to have been exercising EU law rights.
I think another submission you might be entitled to make is that Article 32 is about supplementary means to interpretation.
Yes.
And you submit, you can't change the fundamental words and structure of a treaty to make it say what, with hindsight, perhaps people think it ought to have said.
Yes, and your Lordship is quite right. There isn't actually any supplementary material which suggests. The point we made in our skeleton was we cited Anderson, I think it is, which says it's not the right approach to look at what the parties might have intended if certain things have been in their minds. for the reasons we've given it. I'm happy to go through those.
Yes.
I just didn't want to take up time.
Yes.
But essentially we say you simply cannot ignore the clear terms of Article 10. And I've already made the point that exit has consequences, and some of those, for many people, are not happy consequences. But those consequences flow from the withdrawal agreement.
But people who've been together for 21 months might not qualify because of Brexit. With durable partner, if you're looking for a long period of time, if you're interfering with that, it's just terribly hard on people.
Yes, although such a person could apply, should have applied, and if the Secretary of State said no, and of course it's only a rule of thumb, she looks at everything, if she said no, they could appeal. If those persons were, they had the option to get married, they had the option to leave the state.
Well, I might be happy with my girlfriend, may not want to marry her,
Yes,
but I may be in a durable relationship.
absolutely,
And the
but-
answer is I've put up with her for 21 months, and she put up with me, and I still can't get residence. But you say that's the consequence of Brexit.
And then one
It's
would
not
have
absurd, it's harsh.
one would have to ask, does your person have leave on some other basis? In which case they would be okay. If they didn't, then they were here unlawfully, and regrettably that has consequences, which is that there is no right to remain in a state to pursue a blossoming relationship.
Yeah.
So yes, that there are various human factors at play, but there are no factors which allow this court to disapply the terms of the withdrawal agreement. So grounds 2 and 4 were taken together, and that's the extended family member issue. We made 5 points in our supplementary skeleton, which we developed in some detail, and we stand by all of those points. I've repeated some of those points already in the course of addressing legal topics. What I wanted to do quickly now is just summarise, and I will need to take the court to one more authority. I want to summarise our arguments in response to the various points that have been made in oral submission by the appellant and the interveners, to the extent that I haven't done so. So the first submission I need to deal with is the argument that it doesn't matter that the appellant didn't appeal the earlier decision. The point we took, of course, is, well, if he'd wanted to say, treat my August 2020 application as an application for under Article 3.2, because otherwise I don't get in under Article 10, then he could and should have brought an appeal at the time, and he did not. There's no point in relying on the application which is the subject of this appeal, because it was made after the deadline in Article 10.3. So that we say is a complete answer to this case, and we say it really is that simple. He could have appealed that earlier decision, didn't, and he can't. It doesn't help him to rely on the second one.
Please don't take this out of order, but that does prompt in my mind the question which emerges from Mr. Delamere and Ms. Ward's submissions, which is to do with the wording of paragraph 3 of Article 10. Can we just look at that again?
Yes.
It's page 1267, tab 47. If I've understood it correctly, one of the submissions that's made by the interveners is that where this uses the phrase "who has applied for facilitation of entry and residence before the end of the transition period," that requires simply asking and answering a question of fact, which is, did the appellant apply before that date? And they say the answer is yes, he did, in August 2020.
Well, yes, and our answer to that in substance is no, he did not, as I've submitted.
Yeah, that I understand.
Yes.
Yeah.
But
But on this point about the fact that there was the unappealed decision in March 2021, do you also make the submission that where it says who has applied, that can't be a reference back to an application which has already been disposed of, and in respect of which there is a decision which has not been appealed?
Yes.
It must sensibly, is this right? Your submission is it must sensibly be referring to the second application, which was made after the end of the transition period.
Yes, exactly. And the point is that, I mean, that it's quite difficult to unwrap. It's quite difficult to unwrap the fact that what's needed is an application under Article 3.2a. So if you want to assert that you made an application under Article 3.2 previously and you had an opportunity to appeal it but did not, that it wasn't an application under Article 3.2a, and that you can't now assert, having not appealed it, that it is.
And you've also got the second part, and whose residence is being facilitated.
Yes, so exactly.
Yeah, and it may well be, and this is because they're not in 10.2, you've got to read it in context. They've not got the decision before, they've got the decision after. But even if you get 3 applications by an enthusiastic applier and 1 decision, whichever application it relates to, it's got to be one that's been made before the relevant cut-off point.
Yes, exactly. And then ultimately, of course, it needs to succeed as well. You don't come within scope, but that's right, exactly. And the application that he relies on was not such an application, and if he wants to argue that it was, he needed to exercise his right of appeal. Of course, we say it wasn't in any event, so it doesn't get him anywhere. It's tied to that point, and to answer some points that have been made by reference to a reference to the principle of good administration, could I show the court the decision of the ECJ in a case called Petrea, which is at tab 4 of the authorities bundle. So the facts are at paragraphs 22 to 24 on page 161. Sorry, paragraph should start really at paragraph 19 to explain how he got himself into this pickle. When he commits a crime, he's given a return order, he's sent the information about his appeal rights, and rather than appealing, he says, I'm going to go back home, and he does that in November 2011. The order that he's given bans him from coming back until October 2018, but undeterred, he then comes back in September 2013. He gets lucky, he puts in an application for a registration certificate and it's granted, and then the authorities realise they've made a mistake and they withdraw that certificate and order his return to Romania. And in trying to challenge that decision, he starts to argue about the earlier exclusion order of October 2011, which he didn't challenge. That then leads to the questions to the court, which are at paragraph 28. So the first question asks, are Articles 27 and 32 of the Directive, having regard to the principle of procedural autonomy and the principles of protection of legitimate expectations and good administration, as meaning that the withdrawal of the certificate of registration previously granted, and then it goes on to say, basically, is that permissible? And there's then a whole series of questions. The question which I'm going to ask the court to look at is the fourth question, which begins at paragraph 57. And could I just ask the court to read paragraphs 57 to 65?
To 67.
57 to 65. Propositions I take from this. The first is that when the court is addressing this question, which has been wrapped up in effectiveness and good administration, it says at paragraph 58, the question is whether the procedural rules make virtually impossible or excessively difficult the exercise of EU rights. The second proposition I take from it is that there's nothing wrong with having time limits for challenging decisions, because those are in the interest of legal certainty, provided that the person did have the opportunity to do that. And then third, what you do is look at whether the person did have a proper opportunity to contest the original decision that they're now trying to revive. And the court says at paragraph 63 to 64, well, he was aware of the right of redress. He said he waived all legal remedies, and so he was able to rely on legal proceedings on the possible. It must be held that he had sufficient evidence to have raised that in the earlier proceedings. So, the principle of effectiveness doesn't preclude a legal practice in circumstances according to which a national of a member state is subject to return order can't rely on the unlawfulness of the earlier exclusion order if he was able to appeal that. So, by analogy, I make 2 points in this case. The first is the general idea that something that the Secretary of State has done in continuing her Article 3.2 scheme is contrary to the principle of good administration. It's not, for the same reasons that the court gives here. She's entitled to have time limits. What she needs to do is not make virtually impossible or excessively difficult the ability to access the Article 3.2 right, and that's subject to my submission that it's all for national law. If I'm wrong, and we're in the fifth question of Rahman territory, that's what, if it's to be said that the Secretary of State has breached the principle of good administration, then she needs to have made virtually impossible or excessively difficult the ability to make an Article 3.2 application. She did not. The form was available, it was there, the application to be made, and had it been made, it would have been considered, and there would have been a right of appeal. So that threshold is simply not met. The second point I make is in relation to the argument that, he should now be allowed to challenge this earlier decision that he didn't appeal, and we say that's wrong for the same reasons given in Betrayal. So that case has a dual function. The next submission I need to deal with is that an extended family member application was made in substance, and I think I've dealt with that already in the course of my submissions. We say it wasn't. All it did was use the word durable partner, and it sent 2 documents which showed that they were living at the same address. Can I just deal with this point about Regulation 21? I'm not sure I've understood the point correctly, but the central point we made, and this, as I say, this Article 10.2 of 10.3 point, it featured in the upper tribunal, and the court would have seen it in the tribunal's decision, but the arguments were very different. They were focused on COVID and marriage and so on. Now, the central point we made in the upper tribunal was a simple one, which is, well, why are you trying to rely on Article 3.2 when you didn't make an application at all? And we made the point, you didn't make an application at all, let alone a valid one. So the point is that when the upper tribunal was looking at this point, and in the very brief argument that was made to it, it wasn't deciding a case where someone had filled in the wrong postcode or missed the box. The situation in this case, certainly on our analysis, is that no application was made at all, because the scenario Mr. Delamere was positing is someone who used this form but they missed the box, and he says, well, that would shut somebody out from their rights, because the Secretary of State would say it's invalid, and that would result in terrible consequences. Well, if there really is an extreme prosecutor says no case like that, then let that case be determined on its facts. Let that case, let the argument be run that an application was made in substance there, and EU law requires it to be considered. But it's not this case, and it's not the point that the upper tribunal was making in their submission. When the upper tribunal says that he had made no such application, what it was referring to was the lack of any extended family member application at all. So that's the simple point to the focus on Regulation 21. Yes, the upper tribunal decides that an application under the use is not an extended family member application, but it was absolutely right to do so for the same reasons that I've been submitting this afternoon. So that, in a nutshell, is our response to the submission that there was no application in substance, even if it's possible to just not use the form, because at the very least someone would have to have engaged with what they need to do to get that right. So perhaps, and again, if this argument is to be run, then at least meet and at least address the factors which are relevant to the application. And that comes back to the point, I would say, that Lord Justice Longmore was making in Macastana, which is it's not enough just to say durable partner, because there's a lot more to the application than that.
Can we look, please, at the upper tribunal's judgment,
yes.
paragraph 53, because
yes.
we've heard quite extensive submissions about that from the interveners. And I certainly would be assisted by what, if anything, you would like to say about this. The context is, sorry, are you there?
Yes.
Yeah, you have it. The context is that the upper tribunal refers to Article 3.2 at the beginning of paragraph 51.
Yes, so could I just take your lordship back a point, because the argument it's dealing with fundamentally is that he's a family member.
Yes.
So it starts with that and says that he wasn't, because he wasn't married.
Certainly,
yes.
certainly. But they then refer to the requirements of Article 3.2 in paragraph 51. And then they make a point of fact at the beginning of paragraph 52, there can be no doubt that the appellant's residence in the UK was not facilitated by the respondent before 11 p.m. on 31 December 2020. It was not enough that the appellant may by that time have been in a durable relationship with the person whom he married in 2021. And then, I won't read every word, but paragraph 53 begins with the sentence: if the appellant had applied for facilitation of entry in residence before the end of the transition period, Article 10.3 would have brought in within the scope of that article, provided. And then we can all read the rest of that sentence. This is not, however, the position. Now, if it had stopped there and simply gone on to what it said at paragraph 55, as we have seen, the appellant made no such application, I could have understood that reasoning with respect. And it may be that that's all that the upper tribunal needed to say.
Yes.
Because the fact was that he hadn't, on your submission, made an application before the end of the transition period. But they didn't stop there, though. They went on to say in the second half of paragraph for an application to have been validly made, it needed to have been made in accordance with Regulation 21. I think that's how 21 has come in, and that's why the interveners criticise the reasoning in paragraph 53, and we've been told, by the way, this is now being cited in other judgments, and as I read it, but please help me if I'm wrong, that part of the reasoning is overturned. It's not necessary to the upper tribunal's decision.
But one's got to unpack some different points, because the point that Mr. Delamere is focusing on is, oh, you miss a box, and so Regulation 21 does different things. One of the important things it does is says that you've got to use the form, and the reason it says that is so that you get the information. So I have to say that the argument on this point in the upper tribunal was reached nowhere near the level of sophistication or detail that it reached in this court. And I think in our skeleton argument we made the point that there had been no application, and also referred to the requirements in Regulation 21, which include a requirement to put an application form in. I just read this as the upper tribunal making the point that there just wasn't any application. There wasn't an application made on the relevant form. There was no application at all. I accept that it didn't need to add that reasoning, because one has to read paragraph 53 in relation to paragraph 52. What the upper tribunal's really saying is, look, it's not enough to say you're in a durable relationship. The established jurisprudence is that you've got to actually have the card. Failing that, you've at least got to need to make an application. He didn't. What the rules say is to make an application you need to apply on the form, pay a fee and so on. But there wasn't an argument that the upper tribunal was considering that you could disapply Regulation 21 if in substance an application had been made. As I recall, that just didn't come up. So it actually simply wasn't getting into this level of detail. All the upper tribunal saying in paragraph 55 is he made no such application. But what we say, and I think that there are two concerns of the interveners as I understand it, but the one that's been emphasised is the point about missing a box on the form. But that's not the facts of this case, and I don't read Judge Lane as addressing that situation. That's why I say, well, let that case be decided on its facts. He's addressing a situation that I've made submissions on, which is, well, look at all the questions in the form. None of that was addressed. All he's done is say, as a durable partner, that's not good enough.
It may be that the sentence that my Lord has drawn attention to could be misunderstood, but the one thing that can't have happened in this case was that the document sent in August 2020 was rejected on the basis that it did not include a valid application, because it was refused under EU6, and EU6 says a valid application will be refused if it doesn't meet the requirements. So in substance they were treating it as a valid one, but didn't meet the requirements of the EUSS scheme.
Exactly. So
they weren't treating it as an application that was invalid because Regulation 21 applied. And if that's what Mr. Justice Lane thought, it wasn't what the decision letter said.
Yes, I don't think that was the point he was driving at all. What he was saying was just he didn't make an EFM application. By the way, this is what domestic legislation says you need to do. But your Lordship's quite right that there's two different points. There's the application that actually was made, which was an application under the US, and that was not rejected as invalid. That was rejected, and indeed Regulation 21 wouldn't apply to that. That would be the immigration rules. That wasn't rejected as invalid. It was rejected because it didn't meet the requirements. No application, valid or otherwise, we say, was made under the 2016 regulations. That's the simple point. That's
and
how
if you made any error at all, it was in not treating the application as under.
Yes, because
that's what is the criticism of you, not for saying, well, we've got this application, it purports to be under the EFM Regulations, Article 3.2, but it's not. He's forgotten to put a full stop in box 46, we can get him that way. That wasn't what they did.
because that wasn't what was argued.
Yeah.
No. So, but we say that what you can't do is given that the arguments have now been advanced in this court.
What about, my Lord, I'm sure is inviting you to say, should we correct 53 in the sense that if people are misinterpreting it?
Well, I'm still struggling to understand how people are misinterpreting it, because the concern I'm hearing is that in cases where there's been a simple failure to complete a box, but I haven't seen a case in the upper tribunal where it's that. The case that we were shown, I think, was Emmenbach's, and that's a case where, just like here, all the person did was fill in the EU settlement scheme form. So I'm at the moment not understanding what the practical problem is. I mean, it will be remedied, I suppose, if this court, whatever this court's decision, if this court decides that completing a US application form is making an Article 3.2 application that would overrule Mr. Justice Lane. If this court, having had the benefit of much more detailed and indeed different arguments than Mr. Justice Lane, says we do not accept that this appellant, having completed a US application form and said he was a durable partner, made an application for the purposes of Article 3.2, that would dispose, in my understanding, of many of the cases in the upper tribunal, because that is the argument that's being run, that by filling in a US form you make an Article 3.2 form. Now, to the extent that there are cases which raise more subtle issues, Mr. Justice Lane wasn't addressing such a case. And I mean, certainly from my perspective, if this court were to make clear that this isn't such a case and Mr. Justice Lane wasn't addressing such a case, then yes, but I'm still not at the moment sure that there's a problem in practice with people going to the upper tribunal and saying, look, I only missed the box and I've been shut out of all of my rights under the withdrawal agreement. I'm turning my back. We're not aware of any cases where that's the issue. So I just want to be clear about that, because it's been very much put on that basis. The computer says no, the Secretary of State's depriving people of their withdrawal agreement rights because they haven't filled a box. That's not what's happening. What's happening, and what these cases are about, is whether ticking a box that you're the durable partner is making an Article 3.2 application. So does that, in a very long-winded way, does that answer your Lordship's question about the terms of the upper tribunal's judgment? I shouldn't have got so happy with myself for making good progress. I'll take this as quickly as I can. The submission that proportionality applies, because there's a right to a proportionality consideration under Article 28, I say centulia. The other point, just for the court to know, is that in SM Algeria, which is the case about kafala, that's in tab 2, that's an EFM case. The court does, just for completeness, deal with Articles 27 and 28. It's tab 2, paragraphs 74 and 75. It doesn't really take us much further, but I ought to show the court what the second question in SM Algeria was, and this was a reference from the Supreme Court. Can a child be refused the right of entry or residence as a family member by reference to Articles 27 and 35 of the Directive? That's paragraph 74 at 92. And what the court says is, paragraph 75, and it's consistent with Centulia, is, well, effectively the court says we're not going to answer that question because the child isn't a direct descendant, so it doesn't have a direct family member right. What it does say, though, at paragraph 70 and 71, is that when the court is making the Article 3.2 assessment, it can take into account risks that the child will be the victim of abuse, exploitation or trafficking. So that comes in a kafala case at the discretion stage. So, 73. Sorry. Yes. So, and this is why I referred to this case of SM Algeria, because it's authority for the proposition that at the discretion stage, the charter is taken into account, and we cited it in our skeleton argument for that proposition. So I'm being asked to refer to 73. the second bit of 73, which is exactly it's exactly the proposition that we drew from it in our original skeleton, which is when you are making the assessment of, when you're doing the individual consideration, you look at the charter. And then finally on this ground, we say whatever legal principles apply, whatever legal principles Mr. Delamere seeks to rely on, good administration, proportionality, whatever else he tries to pull out of his back pocket, the point goes nowhere because there's been no breach of any of it by the Secretary of State. And the point is this, his submission was national rules of manner and form or validity cannot impair the substance of a right, to the point that you say because you haven't complied with a procedure, we'll treat you as having made no application. Well, that's not what's happened here. What has happened here is that the Secretary of State has deliberately continued in place her Article 3.2 procedure, which enables her to determine Article 3.2 applications, and she's also set up a discrete process of applying to the EU settlement scheme. I won't repeat it, but we've set out in paragraph 37 of our supplementary skeleton why we say there's been no breach of any principle of EU law. But can I just headline it? And I headlined it at the beginning. We say that it would be contrary to the principle of good administration and legal certainty to impose disproportionate and impractical burdens on the host state, to ferret through applications and to contact people and to help them comply with their rights. And that would also undermine a key aim of the withdrawal agreement, which was to ensure legal certainty for administrative and judicial authorities as well as individuals. So that's our answer to grounds 2 and 4. For completeness, you've also got the decision of the Upper Tribunal in Sadiqa, which is a decision of a panel in the Upper Tribunal of Mrs. Justice Hill and Upper Tribunal Judge Kabede, where they consider similar arguments and reject them, and that's at tab 40. So I can wrap up the other grounds very briefly. Ground 3 was about the guidance. I've dealt with that and it's addressed in our skeleton argument. These other grounds, so ground 2 is our supplementary skeleton, these other grounds are in our initial skeleton. I'm taking these briefly because Mr. Hawking did the same. Ground 7 relates to Article 18(1)(r) of the withdrawal agreement. I took the court to that. I said it's not about, it's got nothing to do with disapplying the provisions on scope in Article 10. Just to say that in his oral submissions, Mr. Hawking made 2 points. He mentioned the case of Sakaridis. He didn't take the court there. For the court to note, that's in tab 9 of the authorities bundle. It's got absolutely nothing to do with this case. It's about Article 27, deportation. He also made a general argument that under EU law, a court or tribunal can conduct a broad-ranging proportionality analysis and disapply the clear terms of EU legislation. That's wrong for the reasons we give in paragraph 36 of our skeleton. If any authority is needed on that point, see NIRGA, which is at tab 18 of the authorities bundle. The passages are sidelined. Ground 8, which is about he qualifies under the immigration rules. We say he does not, and that is clear. Ground 9, the point that we were making in our skeleton is that the Charter doesn't bite as retained EU law. I've explained, I hope, how it does apply in this context. We accept that it applies when one is doing the individual consideration. But what the Charter doesn't do is, and this is not a point that's made by the interveners, what it doesn't allow you to do is disapply the clear provisions on scope in Article 10. Ground 10 was about human rights. I don't think that was addressed orally, but in any event it's academic, because this appellant has now got leave under Article 8. And then ground 11 is a discrimination argument by reference to the position of relevant persons of Northern Ireland. Now, we've explained the background in our skeleton, including in a footnote. The appellant has never engaged with the reasoning of the upper tribunal on this point, nor what we say in our skeleton. The simple point is that different arrangements need to be made for relevant persons of Northern Ireland, because they couldn't provide a document under the 2016 regulations because they weren't eligible for it. Nonetheless, the commitments that the UK has made require it to bring them within the EU settlement scheme, so that's why the requirement doesn't apply to them. And ground 12, which is about public law principles, is irrelevant. One final point to make about the case of AT, and we've dealt with this in our initial skeleton. That case does not assist either the appellant or the interveners, because it's about a discrete point about entitlement to social security, social assistance benefits, and it's about how the case of CG applies in the post-transition period world. And the arguments there, in particular about Article 4.3, are different. One of the Secretary of State's point in that case is that Article 4.3 is not engaged at all. So, we've set out in our skeleton, our original skeleton argument, why AT doesn't help the appellant.
No, we heard yesterday that that case has been heard by this court.
Yes, it has.
And judgment is pending.
Yes, it is.
On your submission, ought we to await that judgment before giving judgment in this case?
I don't submit that it's necessary. It's a very different point. I don't know if Mr. Delamere agrees.
From what I understand, and I think we can say this, it's likely that judgment is going to be handed down this term. There is a hearing convened in that case. Those are the final matters before judgment.
What date?
Don't know as yet, but it's going to be the latter part of this term.
Right, in this judgment, you never know.
As soon as, well, how my Lord cranks out his judgments very quickly. But even allowing for that, I think it might be before that happens. The date is being arranged with the various councils. My learned friends.
If there's a hearing before the end of term, will there be a judgment?
I'm very conscious of
The limitations.
the limitation.
Yeah.
So I'm not going to NCND.
Don't.
In those circumstances.
But I think the question was whether you would suggest that it was prudent, wise, necessary to wait.
The issues, as you can see from Mr. Justice Chamberlain's judgment, are quite heavily focused on the proper operation of Article 4.1, 4.3 and 5, and indeed the obligation of uniformity of result across the EU. I take my learned friend's point because we're dealing with national procedures that may not apply the same way. I think it's likely that you're going to want to consider the contents of any judgment grappling with those issues, even if ultimately you come to the view, in fact, that doesn't move me from the conclusions I've got. I think it would probably be, in my submission, prudent to wait till you have the judgment in hand before you decide it is or is not material in deciding the issues.
They made one of ours.
Thank you.
It's a very oblique answer.
Indeed. Yes, so those are my submissions, unless I can assist on any further point.
No, thank you very much. Yes, Mr. Hawken.
Lords, I've really struggled today, not with necessarily understanding the arguments, but simply with the heat and the air, from my perspective.
Right. Sorry to hear that. Do you want a break now for a couple of minutes?
Yes, if I possibly could, and that will help me.
Yes. Do you want to
be on point?
You gave us this decision. Do you want us to look at it in advance?
That would be very kind. Paragraph 27 to 34.
27 to 34.
I think so.
Thank you very much.
All right.
It's gone wrong.
It does.
Have thoughts.
Oh, yeah.
Oh, that was very well, probably listen on YouTube.
It's just
Yeah, they do it on YouTube all about the chocolate. Oh, I always show myself up if there's something on YouTube. It's something stupid. That's what I read one of the last ones. Well, I forgot to put my wig on and the judge was
Do we say it's really few? This is your original. I don't know how much your point is. We can't handle the full.
no, it's too much.
And also, my thought was honestly, it's saying that do you need to stay? Just let the court go.
Feeling great because
So of the word that was in my head when everybody didn't know what the
Oh wow. I thought you would have had chocolate.
do it easy, the other stuff is not
I meant to change it.
Yeah. That's
And now I'm going to get rid of this. I'm just trying to figure out if I'm going to get
I don't mind the quiet.
I think I can possibly change it. This is a later job. I just had a moment where I was like, oh, so goodness. So I had to do on so many other things.
I know, I hate that when that happens.
It's fine, I don't have plans tomorrow evening.
Nice, why were you going to the that for?
Oh, it's a long-standing backbone, basically very case of sorting out my own life adventure, and I went in November with Miranda actually, and another of my friends, and I was meant to be in court the day that we were due to go in, and I was so sure it was going to settle, so I hedged. The train Eurostar, and I had another ticket later, and you can change them for free, about 7 days in advance, and the hedge paid off. So I just randomly pushed it back to another day, and then randomly pushed it back to another day, and I just randomly pushed it back to tomorrow.
Good to go?
Forgot about it.
We do that in something, we did that and then suddenly thought, oh no, we've got a bit more to Paris or something like that.
If you want to go to Paris tomorrow, I might have a ticket. I think I should. Yes, it's
Yeah.
a shame I didn't say anything to you. I nearly did, and then I was like, the last thing you need is I want to be like, oh, there's a spare ticket.
Yeah. No,
That's the point.
it was outside or...
Flexible or sensible rule.
Oh yeah, it wasn't. I was going to
Near.
no, we're behind the festival, but you can hear it. I mean, it's not great, you know. I can hear it's cold, but I kind of trying to work out which song it was. But I was.
Oh, that's really nice. But it's on the way. But if you're right next to it, then
Yeah, you can think.
Yeah, my friend was certainly asking me managers doing quite regularly. So we listened to, we sat out and listened to Mr. Bush's parents. So, yeah, really clearly. But being subject to white noise.
Yeah, I mean that's it was quite a treat to
Mr. Horgan, it is at the end of a long 2-day hearing. Would you prefer to do your reply in writing? And we would give you, say, until the end of next week to provide, say, up to 8 to 10 pages of submissions in reply. Would that assist you or would that not assist you?
My Lord, that is exceptionally kind, and I have before me an array of post-it notes, but I think given the nature of the case and what your Lordship has said, I think all parties would benefit from written closing submissions or a written reply. I would be very grateful to accept that invitation.
Yes, we'll do that. We'll do that then.
I'm extremely sorry for the
no, not at all. I think actually it would probably help, as you say, it would help us more if you had that opportunity to marshal them into a different form. Maximum 10 pages, is that enough?
Yes. Could I possibly ask for 10 days?
The end of next week?
Yes, the end of next week.
Yes. So by the end of the 14th, I think it is. And obviously send them to us and to all the other parties.
Yes. Your Lordships, I'm greatly appreciative for that suggestion.
Unless we miss it, should AT hit the press, perhaps if they could let us know about AT.
I think we'll hear about that. Yes.
Be sure to send it to you.
Thank you. Right. So that, I think, subject to anything else, brings today's hearing to a conclusion. Thank you all very much for your respective submissions. That I know everybody, well, perhaps not everybody in this call would be involved with, but a lot of you will be and others. So thank you all very much and your respective teams. We are, of course, reserving our judgments in order to address these additional submissions. You'll get the draft judgments in due course. For typographical errors, as has already been alluded to, the use that you can make of the drafts is extremely limited. And we would hope once you receive the drafts you'll be able to agree a draft order, but if not, we'll deal with any outstanding issues on paper. So thank you all very much.